law degree and called to the Ontario Bar. Our main areas of practice are estate planning, estate administration, litigation surrounding those things, guardianship applications for person or property. We also have a corporate law practice. It sort of ties in with my accounting background. And we've just decided to take on residential real estate. So as people come to us to deal with their residential real estate, we often can encourage them to do their estate plans so that if something were to happen to one or both, or if they're a sole owner of the house, there is some plan for where that large investment will go if something untoward happens. So today is strictly about Henson Trust. I guess this is a difficult area for you guys to convince clients that they should plan appropriately for their disabled children. The government is quite strict on how people with disabilities and receipt of disability tax credits and ODSP are allowed to hold assets and how much those assets are allowed to be. So it's important that parents, grandparents, aunts, uncles, if they are going to leave money to a ODSP recipient, that it be done properly so that those disabled people are not precluded from keeping their disability benefits from the Ontario government. Does anybody have questions before I get going? You can raise your hand or put them in the chat, and I'm going to see, I'm going to make, I'm hoping I can make somebody else a host. I cannot. Okay. So if there's no questions, I'll get started. I'm going to share my screen, hopefully make this slide thing run properly. Tech, man, we've been doing this for so long now, and I still get baffled at running the slides. So we'll do it the old school way without actually hitting the run button. So this presentation is really geared towards parents, but it's an easy way for you to sell it because you're going to be talking with the parents. So I thought I'd start with a case and how the Henson Trust actually came to be. There was a young woman, an adult disabled beneficiary under her father's estate. He did his will in 1978 and he passed away in 81. And at that time, you know, that was a lot of money. In today's world, $82K doesn't even meet the threshold for a gift, but at the time it did. So his will was very specific. He appointed 3 trustees. Provisions of the will said, you know, you got to pay the money and the capital for her benefit, their sole discretion. Any income that wasn't paid in any year would accumulate until that 20-year trust rule kicked in. And then any money, sorry, I got people in the waiting room. Any money that was not paid to Audrey in that time period, they would have to distribute that in a different way. It would go to another beneficiary at the end of the day. And then, oops, sorry, I went a little bit crazy on the going forward. So the residue in the income wouldn't vest with Audrey, which meant that it would never be hers. She could never go to the bank and withdraw that money. She could never direct the trustees on how to use that money. There was no vesting. With a regular estate, and when people gain money in a regular estate, the money is handed over to them and they can use it for whatever they want. And that is what we call vesting. Her only interest would be the payments that were actually made to her in the calendar year that they were made to her. The trustees had to maximize Audrey's benefits through other sources so that, she got the full benefit of the government scheme rather than deal with just the money that Dad left for her. And then the trustees had specific authorization to vary those payment amounts so that if she had, extra income somehow, that they could avoid that threshold that the government imposes on people similarly situated. And on Audrey's death, she had no way to direct how any of that unused portion of money was dealt with because it never vested in her. So at her death, any money that was left was to go to an association for, and at the time they used a word that we don't use anymore today. So I've just called it an association. So the question before the court was whether or not Audrey had a beneficial interest in those assets that were being held in trust for her and available to be used for her maintenance. And the Court of Appeals said no. She had no ability to compel the trustees to make her any money or to send her any money. There weren't going to be funds available to her under the scheme if she had access to be able to make the trustees pay her money. So she didn't have a beneficial interest. And that is how the Henson Trust, is because of that case law, became to be known as a Henson Trust. So what is it exactly? Maybe I should ask if there's any questions. No. So a Henson Trust is really a planning tool that allows an individual who is in receipt of ODSP benefits receive an inheritance without losing government benefits. It's a vehicle that allows parents, grandparents, aunts, uncles to park money away to better the life of the ODSP recipient. That doesn't affect any of their benefits. It doesn't affect the amount of assets that they hold, income they can garner, what have you. So because the money doesn't vest with them, they have no access to it, it doesn't affect that asset limit of $100,000. So if that $100,000 is placed in a Henson Trust, then there would only be attribution if they actually received money, right? They're only charged with receiving the money if it's actually distributed to them. So the issue is it has to be in a will. If it isn't in a will, it's not a Henson Trust. They have to do some other kind of trust thing within a very short period of time after the testator's death. And I'll talk about that more further. So a Henson Trust can only be created and then implemented based on the language in the will. So if the language isn't in the will, it doesn't count. You have to do something else. And if it's too much money, then it falls outside the asset limit, and then there can be clawback from the government assistance plan. So the three elements are, it has to be completely discretionary on the trustees. It cannot vest in the beneficiary. There's no requirement for the trustees to be even-handed. Usually they have to take every beneficiary's interest into play when they either invest or dispense or consolidate. In this case, they have no requirement to be even-handed amongst the beneficiaries, which means they cannot pay the ODSP recipient because it would push them over a threshold, or they could pay her or him more money than they would pay another beneficiary because they need more assistance. And then, of course, income can only accumulate and be paid to after that rule of 21 years. So if they exceed that time periods for the laws of trust, then they have to start paying it out to other people. And generally the will address how we pay out to those other people. Sorry, things are going off like crazy. So the advantages is there is no limit on the amount in the trust. So we have had clients put 3, 4, 5 million because the kids are young and they don't know how much money they're going to need or how long they're going to need help. It's not that that money just disappears and goes to that beneficiary. Again, usually on the death of that beneficiary, it gets redistributed, falls back into the residue, and is either redistributed to the beneficiary still alive. If there's no initial beneficiaries still alive, it could go to their children, and on and on and on. The beneficiary in this case would not have to deal with setting up the trust themselves. So if there's an inheritance trust, there are some rules that have to follow, and I'm going to talk about that in a minute. The remainder of the trust can be distributed to other beneficiaries after the death of that trust beneficiary, right? So it's not like the money is lost, it gets redistributed. Other people just have to wait longer. It's a little bit more work for the Henson Trust trustee or the estate trustees. If they're not the same people, they'll most likely have to retain me or someone like me again to get releases drawn off by the beneficiaries that are going to get extra money that they weren't anticipating getting. And we've had to deal with that a couple of times. And the trust can be easily managed for the benefit of the beneficiary, taking into consideration the legislative restrictions. So we always advise our clients to seek really good accounting help for record keeping and financial help for investments and those ODSP sort of limits, because you guys are far more familiar with that than we are. So settling the trust, and this comes up a lot. So the trust is actually made in accordance with the will of the settler. So that would be the deceased or the testator. And the trust is an agreement between the estate and the trustees. And from my perspective, the trust comes into existence when the testator, the settler, dies. It's not when the will is probated. It's not when the assets are consolidated. It becomes a live vehicle on the day that the mom, dad, aunt, or uncle, actually the testator, passes away. Just like when you become an estate trustee, you are responsible to account to the beneficiaries from the date of death until the estate is completely wound up. It's not when you get a certificate of appointment. It's actually from the date of death. So from my perspective, a trust and the settling of the trust happens on the day that testator dies. So the limits for ODSP and assets, and this is why, the Henson Trust is kind of important, is it's limited to $40,000 for a single person and $50,000 for a couple. There are some things that are exempted assets, home, primary vehicle. I've listed them below, are ESPs, RDSPs, etc. And I will talk to you about RDSPs in a few minutes. So if they don't set up a Henson Trust and they want to try and, skirt that issue, or they just want to leave $100,000 to their kid, then we have this trust derived from an inheritance, and that has to be settled relatively quickly after the testator dies. And then the combined capital and income can't exceed $100,000, and that's not a lot of money for someone who may need some extras. And that's, that's the limit. So the trustee or the beneficiary might not get the appropriate legal advice in time to settle the trust. And the trust document is similar to a family trust or a partner trust or an alter ego trust. It sets out some specific legal language and the purpose of the trust, et cetera. And then the beneficiary may lack capacity to settle the trust. And then what happens? Well, then there's a potential guardianship application to have somebody appointed guardian of that property on behalf of the incapable. And from there, there's court supervision until that beneficiary dies. There's a financial plan that has to be approved by the court and the PGT. It runs us about 25K to do that court application because it's an actual hearing in front of a judge. And then they have to account every year to the court and the PGT to make sure that they are managing the assets appropriately for that incapable person. So most of the questions that we get are, who do you appoint? Who do you name as a trustee to manage this trust or even to manage the estate when you die? So what we tell people, it's kind of like running a small business. Yes, you're compensated and you're compensated based on the value of the estate, but the trust could live up to 21, 30, 35 years. It depends how long the incapable or ODSP recipient lives, so that that trust is managed basically for their lifetime. And there are some pretty strict reporting requirements that you have to make sure you undertake. There'll be tax returns. There will be reporting requirements to the beneficiary so that they know how the money is being managed and taken care of. So we tell trustees to make sure that they delegate the work that they're not comfortable doing so that they have professional help to make sure that they don't mess up on the fiduciary duties that they have to this beneficiary. So what happens if you have a disabled kid or a disabled client, but they have capacity to give me instructions? And that's a, kind of a legal test that they need to know that they have assets, where they are. They don't need to know the exact amounts, but they need to have some general idea of what, their assets could look like. They need to know if they have obligations to dependents and what those might be, whether or not they have the cognition to, sorry, 2 people just arrived, whether they have the cognition to be able to manage their assets. They need to know that whoever they appoint as their attorney, if they can give me instructions, could deplete all of their assets. And that they could depreciate at the hands of someone else. Powers of attorney also have legal requirements to report and manage and account as they act on behalf of the donor. And those requirements are quite strict, and oftentimes powers of attorney don't seek help when they are start acting in that capacity, and that can get them into hot water. Everybody knows you should go see a lawyer when someone dies. But when you start acting for mom and dad, and there may be sibling issues, people don't think that, they should get legal advice. They just think they're helping mom or dad pay some bills. And then disgruntled sibling comes along and says, well, you shouldn't have done this or you shouldn't have done that. And then they don't have records, and it can be quite daunting. So if the disabled or ODSP recipient has the capacity to give instructions, then they should be encouraged, like everybody else, to draft estate planning documents, specifically powers of attorney for property and personal care, and a will. If they don't have capacity, then we have the issue of guardianship applications, and those are expensive and costly and time consuming. And there's a whole financial plan that has to be built and approved, and then it goes before a judge, and a judge may have questions. PGT may not approve it. And then you have to report, and you have to report in a court format, not just a pretty spreadsheet. And that is, in our litigation practice, that is where most of the problems come from, is on the accounting side. And I talk way too fast. So now I will open it up to questions, and I hope you have a lot of them.